Good morning. Yes.
May I please, my Lord? Yes. Lordship, I beg to mention item number 3. Here, Lordship, I am appearing for respondent number 1 and V. Shokre.
It's a fixed matter, it was.
Yes. However, Your Lordship, V. Shokre is representing respondent number 3 to 9. Your Lordship is attending to a matter in the principal seat today, Your Lordship. So if this matter can be listed after 2 weeks, my Lord.
After 2 weeks, learned government advocate, Mr. Enangami submits that the Ms. V. Shukre is appearing for respondent number 3
to 9
in this matter, and she is engaged in the principal seat today. And accordingly has prayed for listing the matter after 2 weeks. Prayer is allowed. Learned counsel for the petitioner has no objections. List after 2 weeks. Yes.
Lordship, if I may be allowed to make a mention on item number 22. Lordship, even this matter, I have a similar prayer, my Lord. Item 22,
Shukre's case.
Yes, this again, I am appearing for respondent number 1 and Shokre for 3 to 10, my Lord.
Same order. This also after 2 weeks?
After 2 weeks, my Lord.
After 2 weeks, yes.
I am deeply obliged, my Lord.
May I please, Your Lordship? May I be pleased to mention here on item number 33, 34, and 35. Your Lordship, it was mentioned on last Friday to be listed after vacation. But I think...
33, 34, and 35?
Yes, Your Lordship.
Okay.
Last Friday it was prayed.
Yes, I remember. I think wrongly listed that. Yes. List after the puja vacations on the prayer of the parties. Okay. It's 33, 34, 35. Yes.
Much obliged, Your Lordship.
No, bless my Lord. Lordship, I'd like to mention item number 37.
30?
37 of the
37.
hearing list.
Okay.
Lordship, I've been instructed to withdraw this
Withdraw.
application.
Your Lordship, now the problem, he did not comply. The army person and everything, we went there on the spot, we contacted him, he said he will not come. And he did not comply. Now...
No. What is this matter?
Anticipatory bail, Your Lordship. He was supposed to comply. On many occasions, he did not comply. Last time also, I objected. Your Lordship gave, being gracious.
After that case?
Yes, Your Lordship, that.
And I even directed the IO to send the security.
Yes, security. Along with the security, they went to the spot. At his residence, he waited. He did not come.
But if he's withdrawing, what can we say?
No, Your Lordship, now the problem is if he withdraws. Now this anticipatory bail will be as it is. Now he is going to take this benefit again to other court and like that will become a problem.
When he withdraws, everything will go. The orders, the interim protection, everything will go.
Okay then. Okay.
Yes.
Okay.
The counsel for the petitioner has prayed for withdrawal of the present application. Any liberty? You want any liberty to file afresh?
I'll leave it to the discretion of this honorable court.
No, that's up to you, not the court. Okay, don't say liberty. Prayers for withdrawal of the petition. Prayers allowed. All the other interim orders passed earlier shall stand vacated upon withdrawal. So petition is disposed of as withdrawn. Yes.
Okay. Much obliged.
May I please, Lordship? Yes. My Lord, I beg to mention item number 4 to 16. I'm mentioning on behalf of V. Sokre, additional AG, my Lord. She is out of 4 to 16. Yes. My Lord, she is out of station, so let the matter be come up after 1 week.
After 1 week?
Yes, my Lord.
So that means after vacation, it will come after vacation. Because after 1 week, vacation starts. Yes.
Okay, my Lord. After vacation.
Item 4
to 16.
4 to 16. Okay. Learned government advocate Mr. T. Bapom has prayed for listing the matters after the puja vacation in view of the fact that Ms. V. Shukre, additional AG, who's appearing in the said matters is occupied at the principal seat.
Yes.
Today. So accordingly, list after the puja vacations. Learned senior counsel for the petitioners. Petition.
Appearing for some of the respondents in court cases.
Okay, you just furnish the list. You just put the names, okay? So just search for the respondents. And then petitioners also, there are many of them. Z Zimomi, I think. Z Zimomi.
My lord, I'm informed that she has taken consent.
Okay. Consent. It is also submitted that the consent of Ms. Z Zimomi for the petitioners has also been obtained. Yes.
Much obliged.
Yes, Your Lordship.
Yes.
Lordship, I beg to mention item number 27 on part 1.
27. Yes.
Here, I've instruction to appear on respondent number 7, the comptroller and the auditor general. They have been completed as respondent number 7.
Okay. Do you want to file any objections?
Yes,
Anything?
with regard to whether I'll be an SSC party. This is a criminal petition challenging the FIR. The FIR has been registered on the basis of the CAG report.
Okay. And you are appearing for
Lordship,
CAG.
CAG, yes. So whether CAG would be an SSC party in this case, Your Lordship, that's the issue.
If you are challenging the FIR, then how can CAG be a party? Anyway, you think
We are a constitutional authority, Lordship. So we do audit,
You file your objections.
Yes, Your
See, item 27, Learned Counsel Mr. N. Muzui has entered appearance for respondent number 7.
7.
And prays that he may be given some time to file his objections if so advised. So, list after puja.
After puja.
List
Or
after
should
the
this
puja.
interim?
Puja vacation. Learned Counsel for the petitioner, Mr. Foseko Forte is present. Stop. The interim order passed earlier shall continue till the next date. Yes.
I oblige, my lord.
Obliged.
Lordship, I beg to mention item 26. Lordship, here the counsel for the appellant,
Yes.
Sumi Kakati, she is not keeping well, so we're dragging them up to 2 weeks, Lordship.
Learned Counsel, Mr. Foseko Forte is prayed on behalf of Miss MS Sumi Kakati to list the matter after
2 weeks.
2 weeks as the council is indisposed. So, list after
Valid.
2 weeks. Yes.
Much obliged, my lord.
Yes, Lordship.
Yes.
Lordship, I beg to mention item 17, Lordship. On behalf of Mbimsang additional AG, Lordship. On behalf of respondent number 4, Lordship. We have to file, Lordship, so kindly grant me some time,
You
Lordship.
have to file affidavit.
Yes, Lordship.
Petitioner? Yes. Learned Counsel, Ms. S. Jang submits on behalf of Mr. Im Tim Song for the respondent number 4 that he is yet to file the affidavit in opposition and accordingly prays for how much time?
3 weeks.
3 weeks time
Yes.
to file the affidavit in opposition on behalf of respondent number 4. Stop. Prayer is allowed. Learned Counsel for the petitioner is present and has no objections. Least after 3 weeks. Yes.
And for respondent number 2.
Or respondent number 2. Then where's the petitioner? What about petitioner? Petitioner is not present when the matter is called. He is for respondent 2. Respondent 2. You have filed. Okay. Search appears for respondent number 2 and submits that he has already filed the affidavit in opposition. Yes.
Obliged, Lordship.
List after, how much did you say? 3 weeks, no?
3 weeks, Lordship.
List after 3 weeks.
Much obliged.
Yes.
Lordship, in item number 5, there's intern, WPC 340,
Oh,
which
yes.
was mentioned earlier.
In that list of cases, in 340, you say 340 of 2022, the interim order passed earlier shall continue till the next date.
Obliged, Lordship.
For motion, item number 1.
May I plead, Your Lordship?
Yes, this is wrongly listed actually. List the matter before the appropriate bench.
For motion, item number 2.
May it please your Lordship.
Yes.
Lordship, the petitioner herein has filed this application under section 528 of the BNSS. Praying for quashing of the FIR dated 23/08/2025 and the connected criminal case in respect of GR 94 of 2025 and Women PS case number 10 of 2025. Based on the compromise deed dated 12/09/2025 executed between the petitioner who was the accused in that case of GR94 and the complainant.
Let the respondent also appear. You serve notice.
Lordship, if
Yes.
I may,
Yes.
I have instructions to appear for the sole respondent. Now,
Okay,
in view
sole
of the-
respondent.
Yes, in view of the nature of the terms and conditions executed in the compromise deed, may I pray that this matter will be set on Friday, so that in the meantime I can find an affidavit to confirm the compromise.
Yes. Friday.
Friday morning.
Friday. What about Thursday? Thursday. Yeah. Because Friday is the last day, and I think we may have to travel on Friday.
My lord, here I'm agreeing for respondent number 1.
The present application is a petition under section 528 of the BNSS, praying for quashing of the FIR dated 23/2/2025 and the consequential criminal proceedings in respect of GR case number 94/2025 in connection with Kohima
Kohima Women
Kohima
PS.
Women PS number 0010/2025 under section 78/79/351/356 clause 2/331 clause 4 BNS read with section 66C clause C and 67 of the IT Act 2000 in view of the compromise deed executed between the petitioner accused and the complainant respondent number 2. Stop. Heard learned counsel for the petitioner, Mr. Such and such. Stop. Learned counsel, Mr. Ari Ralu, also enters appearance on behalf of the respondent number 2. You have filed your power.
I'll be filing.
Okay. And submits that he will be filing his Vakalatnama and affidavit. Stop. Learned PP, Mr. Tibapom also has entered appearance on behalf of respondent number 1. Stop. As notices are complete by counsels accepting notice on behalf of the respondents, no formal notice is called for. Stop. List the matter on Thursday. Give the date. I think the 10th.
25.
Or Thursday will be 25.
25, yes.
Okay, 25th as admission, in the admission. Yes.
My lord.
For admission, item number 18.
Please, my lord. Lordship, here the applicant is the brother of the accused. The case of the prosecution is that on 14th of June 2025, the accused was arrested in possession of 70 sub-cases of items suspected to be heroin, which weighs around 739 grams. The FIR is at Annexure 2, page 14 of my petition.
Page 14, 1 4.
Yes, 1-4.
Yes.
The case of the prosecution is that the items were seized from a concealed chamber near the gear lever. There were two occupants. The present accused, he was the pillion or the passenger, and the other one was a driver. I'm not a driver. Now, the case of the prosecution is the seizure arrest was made in the presence of independent witnesses. The seizure memo have also been annexed. At page 22, my lord, the amount seized is, and the items suspected to be seized is clearly mentioned.
Yes, 70 showcases.
Then and there, the accused was arrested and he is under custody till death. And a bail application was preferred before the trial court. However, the same was rejected, and we are here before this honorable court, praying for enlargement of the accused on bail.
Okay,
At Annexure 5.
What are your grounds?
Yes, at Annexure 5. A single batch. This is my entire case.
Annexure 5. Yes.
The only ground of arrest that I have written is the others are all signatures and names and time. For possession and transportation of 70 soap cases weighing approximately 739 grams suspected heroin. Now, my lord is well aware of the law laid down in Vihangkumar, Burkayasta, that the full particulars of the offense, the gist of the accusations, and the basic facts must all be provided to the accused. However, as is clearly evident, the section, the act under which he has been charged with, that is the gist of the accusations, it was never provided to the accused. I may be allowed to place.
What happened to your bail order? It's not readable.
I have annexed the type copy, my lord.
Oh. Okay. Page 32.
Yes, my lord. Page 32 to 33. Also, there is clear violation of the statutory provision. If I may be allowed to kindly refer to section 47 subclause 2 of the BNSS,
BNSS.
which has been held to be a mandatory provision by Burkayasta and Vihangkumar.
Okay, understood. You're trying to say that the complete details were not given.
Yes, my lord. And the act, the section, even that basic thing has not been mentioned. And under section 47 subclause 2 of the BNSS, it is clearly stated that the accused must be informed that he has a right to avail bail, when even if he is arrested in a non-bailable offense. The word uses shall. However, that information has also not been provided. So on this grounds, I pray that the accused may be enlarged on bail subject to such conditions as deemed fit by this honorable court.
Yes, PP.
She may have the CD.
No, prima facie case is certainly there.
Is there?
But this Annexure 5 totally incomplete.
These days, to be fair, the police, they have also taken remedial steps in recent cases. Yes.
No, it's good.
Yes.
They should also learn. Where have you stated in your petition, your grounds? Para 8.
Yes, para 7, my lord. That the grounds of arrest furnished to the petitioner at the time of his arrest on 14/6/2025 is not as per the mandate of Article 22(1) of the Constitution of India, read with Section 47 PNSS 2023. The law is well settled that the grounds of arrest as mandated under Article 22 of the Constitution must contain the grounds of arrest, including the full particulars of the offence, the gist of the accusations, and the basic facts necessitating the arrest. Failure to comply with this requirement would render the arrest invalid to the non-compliance with the constitutional mandate. And in paragraph 8, I have reproduced.
This application under Section 483 of the BNSS, read with Section 37 of the NTPS Act, has been filed praying for release of the alleged accused, Mr. Tho Sarini, THOUSAHRIINI.
My lord.
Oh, this is the applicant.
Yes, he is
Who
the
is
brother.
the accused?
T.H. Paviko,
Where is that?
in the cost list. Yes, cost title, page 2.
Page 2. Okay, Paviko.
Yes, my lord.
Okay, for the release of Shri T.H. Paviko, not the Thao, okay? T.H.P.A.V.I.K.H.O. Paviko on bail. Stop. Para. I've heard learned counsel for the petitioner, Mr. Sintianga, as well as Ms. S. Mire, the learned public prosecutor. Stop. It is para. It is submitted that the accused person was arrested on 14/6/2025 in connection with special case number 15/2025 corresponding to narcotic PS Kohima case number 007/2025 under section 21C and 27A NDPS Act, read with section 61 of the BNS. Stop. It is stated that the accused has been in custody since then and is lodged at the district jail, Kohima. Stop. The only ground taken by the petitioner in the present petition is that the grounds of arrest furnished to the petitioner at the time of his arrest on 6/5/2025.
On
2025. In your para 7, just see your para 7. You have made a mistake. The grounds of arrest furnished to the petitioner at the time of his arrest on 14/6/2025 is not as per the mandate of Article 22 Clause 1 of the Constitution of India, read with Section 47 of the BNSS. Stop. It is the submission of the learned counsel that the law is well settled, that the grounds of arrest as mandated under Article 22(1) of the Constitution of India must contain the grounds of arrest, including the full particulars of the offence, the gist of the accusations, and the basic facts necessitating the arrest. Stop. Failure to comply with this requirement would render the arrest invalid due to non-compliance with the constitutional mandate. Stop. Learned counsel relies on the case of Vihan Kumar versus State of Haryana, reported in 2025 SEC Online SC 269 to support his contention. Stop. Learned counsel has taken this court to Annexure 5 of the petition, which is the grounds of arrest supplied to the petitioner at the time of his arrest. Stop. It is therefore submitted that this grounds of arrest clearly shows that Section 47 BNSS and the safeguards mandated under Article 22(1) of the Constitution of India has been violated, and hence it is prayed that the accused may be released on bail on this ground. So, Learned PP has produced the case diary And upon going through the same, it is seen that there is a prima facie case against the accused person under section 21C and 21A of the NDPS Act. Stop. However, a bare perusal of the grounds of arrest would show that the full particulars of the offence has not been furnished in the grounds of arrest. Stop. As per the requirements of section 47 of the BNSS, the police officer arresting an accused person should communicate to him the full particulars of the offence for which he is arrested or other grounds for such arrest. The police officer is also mandated to inform the person arrested that he is entitled to be released on bail and that he may arrange for sureties on his behalf, even if the offence is a non-bailable one. Such a statement has also not been provided in the grounds of arrest. Stop. In view of the above, this court is of the view that the mandate of section 47 BNSS as well as the requirements of Article 22(1) of the Constitution of India has not been complied with by the arresting authority, and accordingly the present bail application is allowed. Stop. Para. The accused shall be released on bail under the following conditions. Number 1, small one, execution of bail bond of rupees 50,000 with one surety of like amount, who shall be a resident of Kohima. Stop. Number 2, the accused shall not tamper with the evidence and shall not hamper the investigation. Stop. Number 3, the accused shall continue to cooperate with the investigation and shall appear before the IO as and when summoned. Stop. Next, the accused shall not leave the jurisdiction of the trial court without the permission of the court. That's all. That will do. Petition disposed of.
Much obliged.
For admission, item number 19.
Just return this.
Like this, my lord.
Yes.
Lordship, as directed by this honorable court to appear before the investigating officer within 7 days, Lordship. In compliance with this
You have
order,
appeared?
Lordship. Yes, Lordship. On 29/08/2025, they have appeared, Lordship.
The interim order was 21/8.
Yes, Lordship.
Yes, has he been cooperating?
Yes, Your Lordship, even otherwise, Your Lordship, so far nothing has been found against him. That's why arrest has not been made so far, as per the CD that I have received. So at this point,
So we'll regress it?
yes, Your Lordship. This is with regard to both item 18 and 19, 19 and 20.
19.
One is the driver and one is the owner of the vehicle.
This one, the name is
Azad Ali. Azad Ali.
Azad Ali. This application has been filed under section 482 of the BNSS, praying for grant of anticipatory bail to the applicant in connection with FIR number 22/2025 dated 19/7/2025 in connection with Mangkolamba MANGKOLEMDA Mangkolamba PS Mogokchung White GDE capital letters GDE number 05/2025 under section 44 clause A small a NLTP Act 1989. Stop. On 21/8/2025, this court had granted interim bail to the petitioner with certain conditions and with a direction to cooperate in the investigation. Stop. Para. Heard learned counsel for the petitioner, Mr. Such, also heard Ms. Livika, learned public prosecutor for the state of Nagaland. Stop. Para. During it is submitted by learned PP Ms. Livika, basing on the updated. This is case diary or this
Yes,
is
Your Lordship.
basing on the updated
Status.
case status report, submitting on the basis of the status report provided by the IO of the case that the petitioner has been cooperating with the investigation and nothing incriminating has been found against the petitioner, and therefore she has no objections if the interim bail granted by this court is made absolute. Stop. Para. This court has also gone through the status report and has also noted that the petitioner has been cooperating with the investigating agency. So, accordingly, the interim bail granted on 21/8/2025 is made absolute on the same terms and conditions. Petition stands disposed. Then same order.
Yes.
Same order in 20. No.
Yes, 20, Your Lordship.
20. Same order. The only thing is the parties will be different. Names.
For admission, item number 21.
May I please, Your Lordship? Your Lordship, here, when I contacted the IO, Your Lordship, IO stated like that he has already like submitted a church sheet to the thing. And so, yeah, that was the only thing that I received. And so I tried to contact the APP as to know the status of the case. But till now, I could not able to receive back the call. I've been trying to call her back, but I'm not being able to get response from the call. So, Your Lordship...
should we call for the court records then?
Your Lordship,
may I please, Your Lordship?
Yes.
Lordship, my humble submission is that on the last order dated 11th of August 2025, Your Lordship, we were instructed to serve the copies. So we have duly served the copies upon the government as well as the private respondent, Your Lordship. And in the meantime, the IA application, which we have filed in the court of the learned CGM, it's still pending, Your Lordship. So
IA for what?
IA for compounding of offences with regard to that, Your Lordship. And with regard to that, Your Lordship, the learned Chief Judicial Magistrate has passed the order deferring the instant IA application 50 of 2025 till the disposal of the proceedings here, Your Lordship. If we may be allowed to place the order on record, Your Lordship.
Well, if it is within the power of the
Yes.
CGM, it can be compounded. If
Now, Your Lordship, they have already entered in an agreement. So my suggestion was also that like they can go before the magistrate and like they can record their statement, both the parties.
Your Lordship, the matter the IA, even the IA application was more than 4 to 5 months has been lapsed and it's still pending, Your Lordship. And we have approached this honorable court.
What are the sections? What are the sections?
The sections are,
Because if the sections are non-compoundable, then CGM also cannot
Yes.
cannot compound it. 323, 352, 447, 448.
Your Lordship, section 451 is I believe it's a non-compoundable. Yes, Your Lordship. However, Lordship, if I may, Your Lordship, due to some inadvertency, we were unable to place on record a vital document, Your Lordship. If we may be allowed to place that on record also, Your Lordship. That is
What document?
the acceptance of apology by the house owner as well as this 451 is
You file an additional affidavit then?
yes, Your Lordship, but that will only
And what about
delay the
R2?
I have, Your Lordship, I have received a petition from the petitioner.
So are you filing any affidavit?
No.
No.
Yeah, because I have received their mutual consent and agreement that annexing the.
No. Just one short affidavit saying that you are not objecting to the prayer. And you also filed the additional affidavit.
yes, Your Lordship.
And we can hear it. How much time will you take? 1 week?
1 week, yes, Your Lordship.
Heard learned counsel for the petitioner, Mr. and such. Also heard Ms. Devika Leonard PP for the state respondents and Ms. such and such, your name for the respondent number 2. Stop. The learned counsel for the petitioner submits that he would like to file an additional affidavit to bring a relevant document on record. Stop. And the learned counsel for the respondent number 2 would also like to file an affidavit. Accordingly, list the matter after 1 week, and in the meantime, the learned counsel for the petitioner shall file the additional affidavit, and the learned counsel for respondent number 2 is also allowed to file an affidavit if so advised. List after 1 week. Yes.
Much obliged, Your Lordship.
For orders, item number 22.
Yes,
Your Lordship. This is for the appointment of the arbitrator, which has been still going
not
on.
appointed.
But my Lord, in the meantime, we also realize that since, although in the agreement between the Government of India and the Government of Nagaland, the Chief Engineer, National Highways, was made to represent the state. In a normal procedure, the Chief Engineer cannot represent the state. That is the reason why, as a measure of abundant caution, we have implemented the Commissioner and Secretary to Government of Nagaland, Department of Works and Housing as one of the respondents. And
Why is this file so thick? Learned counsel is reflected in the. So who will appear for respondent number 3?
Lordship, it will be yes.
He's on leg in court number 1.
Now you'll have to get instruction from respondent number 3, because respondent number 3 can represent the government.
Yes, yes, Your Lordship.
How much time? 2 or 3 days? Because they just have to say whether they would be willing to go for the arbitration proceedings, and the court will appoint. And who they would like.
Yes, Your Lordship.
Because that panel is there, High Court, Gauhati High Court panel of arbitrators.
Lordship, since I'm not in this case, Lordship.
You get the instruction, and then we'll list it when? Day after? Or Thursday?
Lordship, this matter is taken up by my
Then let it be listed on Thursday, my Lord.
Thursday? You inform him? Who? Mr. Mua?
Angami.
Angami, okay.
He's on leg in court number 1.
Okay. Learned counsel for the petitioner, Mr. Joshua Shekhi, is present. The newly implemented respondent number 3 / Commissioner Secretary to the Government of Nagaland, PWD Department, is represented by Mr. Enangami, learned senior government advocate, who is on legs in the court number 1. So accordingly list the matter on Thursday. Give the date for necessary orders.
Obliged, Your Lordship.
For orders, item number 24.
Yes.
May I please, Your Lordship?
Yes.
Lordship, service upon respondent number 3 and 4 are still awaited.
3 and 4. Learned counsel for the petitioner, Ms. Ayala Inchin.
Yes, Lord.
Is present. Stop. The office note dated 17/9/2025 indicates that notice upon respondent number 4 and 5
3.
of respondent number no, in the office note it is only for R4.
Lordship.
They are newly impleted.
Yes, Lordship.
3 and 4
Yes, Lordship.
indicates that notice on respondent number 3 and 4 is still awaited. Stop. Accordingly, list the matter after 3 weeks awaiting service report on respondent number 3 and 4. Stop. Learned counsel, Mr. Tibapom appears for respondent number 1 and
Respondent number 2.
Search for respondent number 2. You have filed your affidavits.
Yes. Obliged.
After 3 weeks.
For orders, item number 25.
Yes.
Yes, please, Your Ladyship. Your Ladyship, I have instructions to appear for respondent number 2, that is Mr. Anup Kunchi, the then Home Commissioner. Now that Anup Kunchi has been transferred and he has been replaced by new incumbent, that is Abhijit Sinha. So I pray that Abhijit Sinha may also be implemented as a party respondent number 5. Here there are 4 respondents now.
Okay. They will have to do the needful, the petitioner. Yes. Learned counsel for the petitioner, Mr. Sergeant Judge present. Mr. Moa Imchen appears for respondent number 2.
Lordship, I have instruction to appear for respondent number 3 and 4.
For respondent number 3 and 4. And Mr. V. Zimomi for respondent number
3.
3. And V. Zimomi for respondent number 4. So it is submitted at the bar that that Mr. Anup Kinchi is no longer the Home Commissioner, and therefore the new incumbent Home Commissioner needs to be impeached as respondent number 5. So learned counsel for the petitioner has prayed for some time to do the needful. Stop. Prayer is allowed. Learned counsel for the petitioner shall file the impeachment application within 2 weeks. Within 2 weeks from today.
Meanwhile, Your Ladyship will be allowed to file our respective numbers.
Oh, you have not filed?
No, no.
In the meantime, the counsels for the respondents shall also file their baklatnama and affidavits. Yes.
Obliged.
For orders, item number 28.
Who's appearing for the petitioner? Yes.
May I please, Your
You are
Lordship?
yet to file your dusty mode affidavit.
Yeah, Lordship, we have already filed and then,
Filed?
yeah, and then we are taking 2 weeks' time to file affidavit on completion of service.
No, that's why I'm saying you are yet to file that affidavit showing the compliance, isn't it?
Yes, Lordship.
Learned counsel for the petitioner submits that the service on respondent number 2 and 3 by dusty mode has been effected, and he therefore prays for 2 weeks' time to file the affidavit of compliance. Stop. Prayer is allowed. List after 2 weeks. 2 weeks?
Yes, Lordship.
List after 2 weeks.
Obliged, Lordship.
For orders, item number 29.
May I place your lordship? I've received instruction to appear on behalf of respondent number 1 to 5. So I'll be filing my bakalat nama.
Learned counsel for the petitioner, Ms. Kim is present. Stop. Your name is Kim, no?
Yes, Kim Piana.
Piana is present. Stop. Learned counsel Ms. Mo Chungna enters appearance for respondent number 1 to 5 and prays for some time to file her. You have not filed your bakalat. To file her bakalat nama as well as the affidavit. So prayer is allowed. List after how much time?
2 weeks.
List after 2 weeks in order to enable the learned counsel to file her power and the affidavit if so advised. Stop. List after 2 weeks. Yes.
For orders, item number 30.
Learned counsel for the petitioner, Ms. Kim Pin is present. Stop. The office note dated 12/9/2025 indicates that the item has been delivered, the service has been effected on respondent number 4. However, in respect of respondent number 1, the service has not been completed. Stop. Accordingly, list the matter after 3 weeks, awaiting completion of service on respondent number 1. List after 3 weeks.
For orders, item number 31.
May I please, my lady? My lady, I'm appearing through VC.
Okay.
My lady, I'm very sorry. The steps could not have been taken due to some issues with my computer system. My lady, if I may beg a week's time to take the service upon the respondents.
Who also supposed to tell an additional.
My lady?
Additional order dated 25.
Yes. Yes, my lady. I'm yet to receive it from the corporation, from the company, insurance company, my lady.
And what about full respondent?
One of the respondent in item number 31, I have to take the steps. In I think item number 32, they are appearing for the claimant respondent.
My lord, I will be number one. Wakalat nama. I'll be filing my. Power one.
Mr. How much time you said?
My lady, a week's time, 1 week.
Text or to find Praise a lot. Please.
For orders, item number 32.
My lady, similar order may be passed in 32.
Order. But there's no 32
What in 31?
Hearing. Oh.
Hello.
Item number.
Item number.
Yes. Scale of pay.
Yes, madam.
Your
Isn't
ladyship.
this a covered case?
Yes, madam.
Yes. Your ladyship, district level verification has already been done for the petitioner. Ladyship may see page 6, the last page.
Yes. Have you also got a copy?
Yes, madam.
Page 6, yes. Where is the petitioner's name?
And then, your ladyship, this is the letter, page 1 is the communication letter written by the director, your resources, to the commissioner secretary, your resources in sports.
To grant scale pay.
Yes.
And then where is the petitioner's name?
Petitioner's name you will find, worship page, leadership page 4, 59. Serial 59, the last one.
Serial number 59, okay. Driver, search and search, and see.
Okay. Did not attach. No. Pun? Sudah.
Okay, so can we close it? We can
Yes,
close
madam.
it with giving them 3 months' time to complete.
Your Lordship, as per the office memorandum, those fixed employees are already enjoying scale of pay, Your Lordship. So the petition have been approaching this court since 2022, Your Lordship. So short time period may be granted.
But when he gets the scale of pay, they will get it with retrospective effect, isn't it?
Yes, yes.
That certain cut-off date is given.
Yes,
I
yes,
think,
my lord.
Yes.
Yes. But
2
my lord-
months. 2 months.
Yes, madam.
That will do. 2 months time. The present writ petition under Article 226 of the Constitution of India has been filed by the petitioner praying for a direction to the state respondents to grant him the minimum scale of pay. Stop. Para. Learned counsel for the petitioner, Ms. Such and Such, as well as Mr. Moy Imchen, learned senior government advocate for the state respondents. Stop. Para. The case of the petitioner is that he was appointed as driver on contingency basis attached to the District Youth Resources Officer Peren on a fixed pay of Rs 3,000 per month for a period of 1 year with effect from 1/12/2011 by order number DYRS/ESTT-6/2010 dated 8 December 2011. Stop. The petitioner's service was extended from time to time, and the last extension order was Office Order number Office Order Number DYRS/ESTT-1/2014 dated 9th December 2021. Stop. Para. It is submitted that the petitioner submitted representation dated 2022 to the Directorate of Youth Resources and Sports, Nagaland, seeking for granting minimum scale of pay, comma. However, the same was not considered. Stop. Para. On 6/6/2022, the petitioner filed a writ petition being WPC number 99K/2022 before this court for granting minimum scale of pay, which was disposed of by order dated 9/6/2022, directing the state respondents to consider and dispose of the same within a period of 3 months from the date of receipt of a copy of the order. Stop. Accordingly, the petitioner's counsel served a notice dated 17/6/2022 to the respondents. Where is that? 17/6/22.
Annexure 6, my lord. Page number 25.
To the respondents to consider the payment of his monthly salary with scale of pay and to dispose of the same within a period of 3 months from the date of the court's order. Stop. However, without considering / disposing the same, the impugned office letter dated 30/6/2022 was written by the Additional Secretary to the Government of Nagaland, Finance Department, Nagaland, to the Secretary, Youth Resource and Sports Department, Nagaland, Kohima, and impugned office letter dated 13/7/2022, written by the Director, Directorate of Youth Resources and Sports, Nagaland, stating that there is no scheme or provision for grant of scale of pay to fixed paid work charge employees. Stop. Being aggrieved, the petitioner has come before this court. Stop. During the pendency, that scheme came, isn't it?
Yes, my lord.
Where is that?
Yes.
Para. Learned Senior Government Advocate Mr. Moa Jamir has submitted that during the pendency of this petition, the state respondents have come out with a scheme which is at office memorandum number AR-3/GEN-67/2001 dated 5th March 2025, by which the state government has provided for conversion of wages of work charge and casual employees to scale pay as per revision of pay, open bracket, ROP, close bracket, 2015. Stop. By the said office memorandum dated 5th March 2025, the state respondents have decided to grant the scale of pay to all work charge and casual employees in all departments whose names have been duly verified by the district level verification committee and registered in PIMS, receiving fixed pay to be granted scale of pay as per the ROP 2015 with effect from 1/4/2025. Stop. Learned Senior Government Advocate has therefore produced the documents.
Your Ladyship, page 1 may be used. May I read the page 1?
Yes, yes.
To the Commissioner and Secretary to the Government of Nagaland, Youth Resources and Sports Department, Nagaland, Kohima. Subject forwarding of proposal for grant of scale-up pay and respect of Sri Durishang Tiswang, driver, contingency fixed bid, and for inclusion as casual employees under the Nagaland Worker and Casual Employees Regulation Act 2001. I'm sorry. Sir, on the subject cited above, I have the honor to forward here with the district level verification report in respect of Sri Durishang Tiswang, driver, contingency paid under the Directorate of Youth Resources in Sports attached to DYRSO Beren. In this regard, it is to state that the white letter number so-and-so dated 9/4/2025, we have earlier forwarded the list of employees who have not undergone the district level verification committee, which includes the incumbent. However, by a circular number so-and-so dated 22/7/2025. Your Ladyship, you will find the circular and
It's okay.
page 5.
We will refer to these. We will refer to these documents in the order. Yes. What did I say last line? Produce the documents, specifically the letter number DYRS/ESTT-20/2024/929 dated 8 September 2025 under the heading Forwarding of Proposal for Grant of Scale Pay in respect of Sri Derohing TEIROHEING Diswang DISWANG, driver contingency fixed paid and for inclusion as casual employees under the Nagaland Work Charge and Casual Employees Regulation Act 2001. Stop. In this letter dated 8 September 2025, addressed to the Commissioner and Secretary to the Government of Nagaland, Youth Resources and Sports Department, Nagaland, Kohima, the Director of Youth Resources and Sports has written to the government to include the name of the petitioner appearing at serial number 59 in the list of employees to be treated as duly verified by the district level verification committee and to give approval for granting scale of pay to the concerned employee with effect from 1/4/2025. Stop. Accordingly, the learned senior government advocate submits that the matter is already under process to grant the scale of pay to the present petitioner, and the petition may therefore be closed in terms of the said letter dated 8 September 2025. Stop. The court has considered the submissions of the opposing counsel for the parties and also produced the letter produced letter dated 8 September 2025 produced by the learned senior government advocate. Stop. It is seen that the Department of Youth Resources and Sports has already started the process of granting the scale of pay to the petitioner herein, and therefore this court is of the view that the present petition can be closed with the direction to the respondents number 4 and 5 will do. Respondents number 4, 5, 7, 8, 9.
Not necessary.
Oh, we'll just say state respondents, to the state respondents to complete the process of granting the scale of pay to the petitioner. Do you have anything to say?
No, Lordship, this is purely to do with the state.
Yes, yes.
And for the AG.
Yes. You just say in that list of vocational learned counsel, Mr. N. Muzzi for the advocate, for the accountant general. Yes. Then dispose of the same and such with the direction to the state respondents to complete the process of granting complete the process of issuing the necessary orders for granting of scale pay to the petitioner within a period of 2 months from the date of this order. Yes.
Published.
That's disposed.